Just after Jack's death, and still in grief, I came home from work to find my garden was being destroyed. Instead of doing a proper job to fix the drainage problems of the property, Andrzej and Dana decided to put in a retaining wall. At first it appeared that they were building the wall out of brick, but instead they used wood. A man who lives in our neighborhood working for the building and planning department for the city was amazed at such stupidity. By building this wooden retaining wall, only increased Andrzej and Dana's liability in future floods.
Nice landlord, eh? He said I could have a garden here, and then he goes and stomps all my flowers down. Nice landlord.
This liability will be transferred to the new owners of the property. Not only do Andrzej and Dana disrespect their tenants, but as landlords they fail to acknowledge that it is we, the tenants, who pay for them to own this property. It is we, the tenants, who pay the property taxes. To that end, in just over 2 years, we paid more than $30,000, and times that by 3. That is almost $100,000 from the 3 units. They disrespected in eliminating my garden and the poppies planted in remembrance of Canadian soldiers and Michelle Lang. On September 23, 2011, Andrzej and Dana made their yearly demand for post-dated checks to extend our tenancy to September 30th, 2012. They accepted 12 checks, thereby continuing our contractual agreement from October 1st, 2011 to September 30th, 2012. Needless to say, it came as quite a shock to us that Andrzej and Dana claimed that just 6 weeks later, they sent a registered letter to us as a notice to terminate our tenancy at the end of February. We received nor signed for any such notice. And I would just like to add that in no other province in Canada can a landlord evict a tenant in the middle of winter. We first learned of their intention to evict us from a third party. What a violation of our privacy! In subsequent letters, we maintained that we had not been delivered a notice to evict us, and from the tracking number they provided to us, we looked up Canada Post tracking information and learned that Andrzej had made errors in addressing. Even in his letters to us, there were errors in addressing. So we wrote back to him telling him we had no intention of leaving on February 29th, that he has accepted payment to the end of September 2012, and he has no lawful reason to evict us. Our rent has always been paid, we keep our residence clean, and we even do yard work. We are also the longest tenants living in this building. On or about February 7th, 2012, we found this notice taped to our door, further violating our rights to privacy. This notice ought to have been in an envelope. We were being ordered to appear before the Residential Tenancy Dispute Resolution Service hearing on February 10th, 2012, less than 3 days after the delivery of this notice. They further delivered us with 2 more documents a day later, contrary to the rules and the procedures of the Residential Tenancy Dispute Resolution Service. In his application, Andrzej admitted that he unlawfully overcharged us by $400 in security deposits. What he fails to mention is his threat to evict us if we didn't pay him an extra $1,000. Even though we are the longest residing tenants, Andrzej has been told by the Calgary Apartment Association that this is the way to evict his tenants. The Residential Tenancy Dispute Resolution Service is not a court of law. An order can be made against us. We know that Andrzej and Dana didn't have a leg to stand on. The signature in the Canada Post documentation was neither Kody's nor mine, despite the claim that a CD had signed for the letter. I had not. I am positive that our mail lady will verify that. The Canada Post documentation provided to us supplies a tracking number, but there should also be documentation associating the tracking number to an address. It is called the original receipt. This document has never been provided to us.
I was prepared for the hearing as best as I could have been, without having legal representation. I was confident in the truth my documents could prove as fact. My landlords had been the victims of the Alberta real estate market and their own poor choices. I was not seeking compensation for myself or their incarceration at that time. I only wanted what was right under the law. The representative of the Residential Tenancy Dispute Resolution Service treated me as a non-person. The law is on my side. The facts are on my side. The truth is on my side. None of that mattered before the agenda of Patty Leahul. I was violated by those whose responsibility was to the laws and Constitution of Canada.
The hearing was conducted by Patty Leahul, calling herself not a dispute resolution officer as documentation suggests, but as a representative of the Residential Tenancy Dispute Resolution Service.
When the representative first came out, she was coaching Andrzej. She wanted him to file paperwork that had not been filed up until that point. I didn't know what the paperwork was, but she was insistent that he filed it. Eventually his wife, Danuta, took him over to the counter so that he could file this paperwork.
The paperwork Leahul was coaching Andrzej to file was an affidavit of service similar to this one. This is a document we have been denied. We are not even allowed to look at it on file.
When we finally got into the meeting, she started the meeting before I even had a chance to sit down. I hadn't even pulled out my documents out of my briefcase yet. She swore everyone in right then and there. The Bible wasn't present. She allowed Andrzej to speak first, and he went through his case. It sounded like he was scripted in what it was that he was there to say. When it came my turn to speak, I was not allowed to present my evidence. I had extensive documentation. Andrzej did not have the initial receipt that would prove that he sent a notice of eviction to my home. He couldn't present it. He didn't have it.
Kody presented Leahul with vital tracking information showing addressing errors, but
Representative Leahul stated very clearly that she would not be accepting any information that I could provide. She would not accept any evidence that I could provide. The tracking information showed that there were addressing errors with the original documentation that was supposedly sent to us. When it became apparent that Andrzej could not prove that he had sent the notice of eviction to us, he stated that he had posted it to our door.
Andrzej Samusz swore under oath that he posted this door on November 4th, 2011 after he posted the letter.
Nowhere before had this statement ever been made. It was completely unsubstantiated. And Patty Leahul said that she believed him.
If this was actually the case, then why did Andrzej not report the November 4th posting on page 2 of his application? Unfortunately, item B, the notice to terminate our tenancy, is of such poor quality it is both hard to read and even harder to reproduce. Andrzej reported on his application that the Canada Post item C document shows that the notice was delivered on November 23rd, but it is another one of many factual errors made by Andrzej. Patty Leahul accepted 2 pieces of correspondence that were from Andrzej Samusz to us as evidence. They were filled with factual errors and hearsay. In both these letters, Andrzej is adamant that he posted a letter. With this, there is no dispute. He posted a letter. In his December 2nd letter to us, he personally delivered it to our door. It has an addressing error, as did the envelope. The letter states that Canada Post delivered the notice to us on November 11th, 2011. But we pointed out to him that this was a holiday. There was no mail delivery. So he changed the date to November 23rd. We have since found out that this is also incorrect, as Canada Post documents state that the letter was delivered on November 9th. Yet nowhere in his 2 pieces of correspondence does he even mention once posting our door on November 4th. Why? Because he lied to Patty Leahul. She knew this was a lie, thereby suborning perjury.
It was very clear from my testimony that Mr. Samusz had not presented any evidence that he had presented a notice of eviction to us, and he had never presented a notice of eviction to us.
Yet Patty Leahul was somehow compelled to evict us on 19 days' notice. Andrzej appears to have lied about posting these documents on February 6th. He actually did 2 postings, one on the 7th, another on the 8th. So Andrzej had to file 2 affidavits of service as required by law. One of the most vile aspects regarding this hearing, so obtusely conducted by Patty Leahul, is the fact that she entered personal correspondence as evidence. At no time during the hearing were these words ever uttered. Tenant has advised landlord they will not vacate. This line was taken out of context from one of several pieces of correspondence written without prejudice to Andrzej and Dana Samusz. Every other legal professional in Canada knows that letters written without prejudice have absolutely no standing in legal proceedings, quasi-judicial or otherwise. Andrzej and Dana's letters filled with factual errors, libelous misinformation, and hearsay must be given the same respect. No legal professional worth their salt would have ever allowed these letters as evidence. Somehow Patty Leahul believes that she is above the law. This is further supported by the fact that once Patty Leahul coached Andrzej and Dana Samusz several times on how to file an affidavit of service, she then became obligated to ensure we had a copy. But she did not. Why have we been denied our right to a copy? The very same J.H. who accepted the application is the Jeff Harrison who denied me access to our file. It is also interesting to note that the application was filed on February 3rd, a whole 7 days before the beginning of this hearing, yet it took Andrzej and Dana Samusz another 4 days to deliver the notice upon us. After this kangaroo court of a hearing, we did a little research and found out the reason why Patty Leahul and Jeff Harrison have prevented us from seeing this document. As you can see, the affidavit of service is clear that if we were informed of an eviction by registered letter, Andrzej was obligated to provide Exhibit A, the originating Canada Post receipt, again proving that Patty Leahul believes herself to be above the law. From the Residential Tenancy Dispute Resolution Service's own handbook entitled The Rules of Practice and Procedure, it states a need for a simple process for resolving disputes in a manner that is fair, informal, accessible, inexpensive, expeditious, and amicable. Well, that's how they may treat the landlords. As tenants, we found this process anything but fair. Patricia Leahul is not an expert in municipal affairs, as the doctrine claims she is. In fact, we have connected Patty Leahul to the Calgary real estate industry, an industry that supports the landlord and that stands to gain over $100,000 on the sale of Andrzej and Dana's property. We both forwarded letters to the province of Alberta, but the Conservative government has refused to right this wrong. The Government of Alberta throws thousands of tenants out onto the streets every year, and they wonder why they have such a homeless problem. There is clear evidence that in Alberta, a criminal element exists with tentacles in the Government of Alberta, the judiciary, the Crown Prosecutor's Office, and that's where Patty Leahul used to work, and in the police. These guys control a lot.